They didn't read me my rights. My name is Frey, and I am a criminal defense lawyer with the Frey Law Firm. One of the most common questions I receive from clients is what impact it may have when law enforcement fails to read the Miranda rights to a suspect or a defendant, even if they're arrested. So, let's look at that. What happens if the police do not read a suspect his or her rights? So the Fifth Amendment to the United States Constitution provides that no person shall be compelled in any criminal case to be a witness against himself. In the case of Miranda versus Arizona, the United States Supreme Court held that the privilege against self-incrimination also applies to the pretrial interrogation of the accused. So, do the police always have to read a person his or her Miranda rights? Well, many are surprised. There is no rule that law enforcement must read a person their Miranda rights every time they're detained or even every time they're placed under arrest. Certain conditions must be present in order for the Miranda rights requirement to trigger. So there's really two aspects to this analysis. First of all, the person has to be in custody and they have to be subject to interrogation by law enforcement. So there's two prongs to this test. Number one, are they in custody? And number two, if they are in custody, were they then subject to interrogation by law enforcement? To shorten up the two prongs, we call it custodial interrogation. So when somebody is subject to custodial interrogation, prior to the interrogation starting, law enforcement must read them their Miranda rights. If a person's not in custody, then there's no requirement that the rights be read prior to questioning. Similarly, if a person is in custody, even if they're arrested or in jail, but they're not questioned or interrogated, then there's no requirement that the rights be read under those circumstances. Only when both elements are present, they're in custody and being interrogated, that's when the requirement is triggered. So, specifically, law enforcement is required to properly advise the person of their right to remain silent and their right to counsel prior to commencing with any interrogation when the suspect or defendant is in custody. Further, prior to the questioning, the person must waive their rights before it starts. So a couple of questions. Number one, what is custody? So for a person to be considered in custody for Miranda purposes, there's no bright line rule. For instance, a person could be in custody even if they're not under arrest. In fact, a person could be considered in custody for Miranda purposes even if an officer explicitly says you're not in custody. And the reason why is the test that the courts employ to determine whether a person is in custody is how a reasonable person would interpret the circumstances. Specifically, would a reasonable person consider him or herself in custody in such a situation? So as a result of this standard, there's a great deal of litigation between defense lawyers and prosecutors as to whether a suspect was in custody or not. And it's a very fact-based inquiry. It requires persuasive argumentation in order to prevail. It's important to argue that the totality of the circumstances demonstrate that the person was in custody if you're on the side of the defense. If that can be accomplished, then the first prong of Miranda is met. So again, it's a fact-based inquiry, and all factors can be considered to determine if the person is in custody. Is it possible a person could be in the back of a police car but not in custody? Yeah, it's possible. I mean, there could be other evidence or information. Perhaps the officer, it's all recorded, and the officer says, listen, you don't have to stay here. You can hop out of the car if you'd like, but if you'd like to talk to me, you certainly can. Okay? So maybe the person's not in custody. In fact, I've had cases where people give statements in the back of police cars and they're very clearly could leave. They were not detained. They weren't handcuffed. The doors weren't locked. And the officer explicitly told them, you don't have to talk to me. You can step out of the vehicle. You can leave right now. Okay? In other cases, perhaps it looks like the person was free to leave. Maybe the officer's even saying you're not in custody, but the circumstances dictate that the person is in custody. If a person's in handcuffs and the officer says, hey, you're not in custody, well, Listen, that's a situation where when you look at the circumstances, the totality of the circumstances would demonstrate that the person was, in fact, in custody. So, number one, custody. Number two, interrogation. So what is interrogation? Interrogation, for purposes of the Miranda analysis, doesn't have to include, a dimly lit, small, smoky room within some police station. No. The test for interrogation is whether the statements, the words, the actions, the questions of the law enforcement officer are such that they're likely to elicit an incriminating response. So again, as a result of this standard, there's a lot of litigation that can occur in order to determine whether the conduct of the officer amounted to an interrogation for purposes of Miranda. Because even if a person is in custody, if there's no interrogation, then there's no need for the Miranda warnings to be read. Okay, so you can imagine a situation where somebody's in custody. Let's say they're in cuffs, they're in the back of the cruiser, or they're in cuffs and they're at the station. They're clearly in custody. There's no doubt about it. They've been placed under arrest, but the officers aren't questioning them whatsoever. There's no questions about really anything. They're not asking about the case. They're not asking for any confession. They're not asking for information. So in situations like that, there's no requirement that the Miranda rights be read. So this interrogation requirement is very fact-based, again. And there's exceptions to it. There's the public safety exception, and we don't have to go into that here. Obviously, this is not a comprehensive presentation. But the bottom line is, for Miranda requirements to kick in, there has to be custodial interrogation. So, if there is custodial interrogation, then the suspect in custody must be read the Miranda warnings prior to the questioning. And they have to waive their rights. So, pursuant to the Fifth Amendment and the Supreme Court's Miranda decision, the suspect must be informed of, number one, their right to remain silent. They have an absolute right to remain silent. Number two, the explanation that anything that they say can be used against them. Number three, their right to an attorney. And if they can't afford an attorney, one will be appointed. So, that's the basic nature of the rights that have to be read. Different officers meet those elements in different ways. Oftentimes, police officers have a card that they will read. Other officers have paperwork that they will actually read and even have a signature for the waiver. But it doesn't have to be a signed waiver. It's not necessarily something that needs to be signed by a defendant, but there has to be a valid waiver. Okay, so the waiver has to be knowingly and voluntarily made. So prior to conducting the custodial interrogation, law enforcement must inform the person in custody of their rights, and the person must voluntarily waive those rights. If the rights are asserted, okay, so if the person demands the right to remain silent or requests an attorney or refuses to waive their rights, then there's no waiver. And if there's no waiver, then no custodial interrogation should proceed. If the rights are read and then voluntarily waived, well, at that point, custodial interrogation can legally and constitutionally proceed at that time. So next, what happens if a person's Miranda rights are violated? So, if law enforcement commences with a custodial interrogation without properly first advising a person of their rights and securing a voluntary waiver, any and all statements made during the interrogation can be excluded from evidence at trial, pursuant to what we call the exclusionary rule. So, essentially, the exclusionary rule serves as a deterrent to ensure that law enforcement follows the mandates of the Fifth Amendment and Miranda. The last thing law enforcement wants to do is successfully interrogate somebody, gain a confession, or gain statements that are incriminating, and then later not be able to utilize those statements or that confession in court. So they have to follow the rules. If they don't, the defense attorney and the defense can possibly examine that issue and litigate that issue pertaining to Miranda in a criminal case. In those circumstances, defense counsel reviews the discovery and the evidence, drafts what's called a motion to suppress if it's warranted, and will proceed to argue that the defendant's Miranda rights were violated and that any and all evidence or statements secured as a result of the constitutional violation should be suppressed pursuant to the exclusionary rule and what we call the fruit of the poisonous tree. So, again, in a criminal case, there's an analysis that the criminal defense lawyer should conduct anytime a defendant makes a statement to the government, to law enforcement, and law enforcement is then trying to use that statement against the defendant. And what we would be looking for is, was there custodial interrogation? And if there was, if the defendant was in custody and interrogated, prior to the start of that custodial interrogation, the defendant should have been read his or her Miranda rights. And not just read the rights, but also voluntarily waived those rights. Okay? If those elements are not present, then yes, there's a possible Miranda violation. And if there's a possible Miranda violation, it can be litigated. And if it's litigated successfully, the court will then, at that point, exclude those statements from trial, meaning the government cannot introduce those statements at trial against the defendant. So that's a big penalty in the event of a constitutional violation such as this. Now, some of the common questions that we receive, oftentimes police don't Mirandize the suspect or the defendant. And generally the reason is because they're not trying to interrogate them. Generally the reason is they already have the evidence that they need to make the arrest, or alternatively, they're in a position where statements have already been made and there's no need for custodial interrogation. So again, if officers knock on a person's door and the person comes out, greets the officers, speaks with them voluntarily, not in custody, answers their questions, well, that's not a custodial interrogation generally. So there's plenty of cases where individuals are not read their Miranda rights. And I think the general expectation, because of what we see in the movies and on TV, I think the general expectation is that every time somebody is placed under arrest or has interaction with law enforcement, they should be read their rights. Okay, again, there has to be custodial interrogation, but I say all of this, it's very important for this analysis to be done in a criminal case. It's very important that the lawyer look at the evidence, look at the information, communicate with the client, get all the necessary input to conduct this analysis to see if this type of motion should be filed with the court, to see if there was in fact a violation of the defendant's constitutional rights. So the other thing that I would like to note is that with respect to Miranda violations and with respect to interaction with law enforcement, again, it's important that the rules are followed. It's important that the Constitution is followed, because these violations can be very serious. And if you look at the history of why we have Miranda rights in the first place and why these were put in place, you can look for yourself at some of the cases. Back when confessions used to be coerced in such a way that they certainly would not be deemed voluntary. Horrible, horrible examples of abuse in order to sustain a confession. So, thankfully we have these rights and thankfully we have these protections. One of the other things that I will note is you would think that suspects, especially somebody who might have done something wrong, would generally exercise their rights rather than speaking with law enforcement. What I find, though, is most of the time people do make statements to law enforcement even after having the rights read to them. Oftentimes the officer sits down with them, and I've seen videos of this, hundreds of videos, where the investigator, the detective, the FBI agent sits down with the client and presents them with their rights, the waiver of rights form, goes over it very quickly, and the client signs it and just starts talking. Okay, and obviously this all happens before an attorney's involved in the case. Generally speaking, and there's a lot of information out there regarding this, but generally speaking, you have the right to remain silent. Making statements to law enforcement is often a very risky proposition. And again, I'm not advising anybody through this, but what I can say is that there's a lot of literature out there on this subject, and generally speaking, law enforcement is highly trained at conducting interrogations. So they're highly trained individuals. They do this day in, day out. And if a suspect thinks that they're going to talk their way out of something or outsmart law enforcement or make false statements, people get in trouble for that all the time. They sit down, and even if they didn't do anything wrong otherwise, perhaps they make a false statement or something that's taken out of context and then labeled as a false statement. Well, if that's made to a federal officer, that in and of itself is a federal crime. So again, you have the right to remain silent. You have a right to an attorney. If you can't afford an attorney, one will be appointed for you. It's important to know your rights. These are very important rights that we have in this country. So I thank you for your time. Again, if you have questions regarding Miranda, if you have questions regarding whether your rights were violated in any circumstance by law enforcement or in a criminal case, I invite you to contact the Frey Law Firm. We'd be more than happy to talk to you. Thank you.